In Penal Code Section 243.4, California law defines sexual battery as touching the intimate parts of another person without their consent for sexual gratification, sexual arousal, or sexual abuse. Now, intimate parts is defined as the buttocks, the female breast, or the genitalia. And the classic example of a sexual battery is a guy who's drunk in a bar, and he's drinking with his buddies, and he reaches over and he pinches the butt of a cocktail waitress. And he's having fun. He really doesn't think anything of it, but she's very offended, and she calls her manager, they call the police, and the person gets arrested for sexual battery. Now, it's a very serious offense. It's a wobbler. So it could be filed as a misdemeanor or a felony. If it's filed as a felony, the person could face up to 4 years in state prison. But perhaps the worst aspect of a conviction for sexual battery is that it requires you to be a registered sex offender for life. So you'll be on Megan's list, you have to register every year as a sex offender, and that's a devastating consequence for people in terms of their reputation, their standing in the community, their ability to obtain employment. So if you're charged with this offense, if you're accused of this offense, you want to do everything possible to fight the case and keep it off your record. Now, sexual battery is one of those crimes where a lot of people get wrongly accused and sadly wrongly convicted. And we find, first of all, that there's a lot of false accusations, that a lot of times an alleged victim, out of anger or jealousy or for some ulterior motive, will make a false accusation of being sexually battered. We also find in a lot of cases that the person had an honest and reasonable belief that they were acting appropriately, that the other person would not be offended. So it might be a situation where you're flirting with someone and the person is flirting back, and you make some kind of sexual gesture which you feel the person is inviting. And maybe you've misread social cues, maybe there's no meeting of the minds, but you're certainly not intending to offend the person. And you feel that there's at least an implicit consent to the contact. These are cases where we've had a great record of success over the years in getting charges reduced or dismissed. We had a case where a client was at a baseball game, and he was arrested for sexual battery. And basically he was accused of reaching over and grabbing the breasts of somebody who was seated in front of him, some stranger. And the police report said that she had identified him as a person who did it. But we sent an investigator and we went and re-interviewed the alleged victim. And when we did that, what she said is really that it was kind of a chaotic situation, and she turned around and she assumed that it was our client because he was closest to her, but she didn't really see him specifically doing it, and that there were other people around who could have done it as well. When we got this witness statement and we brought it to the prosecutor and they looked at it, they dismissed the charges.